Okay. Go.
You hand me my screen box. Now go. Freak.
Jefferson County District Court is now in session. Commissioner Paul will present.
Be seated, please. This is case 24-29, and I'm going to start, Ms. Johnson, for you, or Ms. Jordan, I'm going to start by hearing this preliminary matter before we get into the merits of anything, and then we're going to go from there, okay? All right, so go ahead.
And Your Honor, there's a brief right over there if you want to follow along, because it's the first 2 pages. So, Your Honor, it's my position that this is res judicata. This has already been litigated.
Okay.
And Ms. Jordan failed to put in her original request, the original petition, that these matters were pending. They were already pending. She didn't put them in her petition. And but for that, I doubt the court would have even heard them. Starting on January 2nd, my client filed a petition against Ms. Jordan. Ms. Jordan then filed what I would call a retaliatory petition on January 9th. And these are both in Kitsap County Superior Court. So Kitsap County Superior Court, he files on the 2nd, she files on the 9th. They set the hearing for her petition for February 8th, which was eventually issued an order, which we have not been able to serve. We've been trying to get it served, and she now is on notice that under Kitsap County Superior Court 24-2-0006-18, there is a protection order protecting Michael Johnson against Ms. Jordan, and she's now on notice of that. And I have a copy right here. And so now when he has these both pending, she then comes into Thurston County on January 22nd and files a petition after there's already an order against her, a temporary order against her, and she's filed a petition also that's awaiting hearing. And my speculation is this as to why she
Your
did
Honor,
this.
I didn't file anything in Kitsap. That was somebody.
Ms. Jordan, hold on. Let me hear from counsel, and then I'm going to get your response, but don't interrupt, okay?
Okay, she says she didn't file anything in Kitsap, so I want to address that. It's in Kitsap, it's 24-2-00066. There's a copy on here is Exhibit 2.
Okay.
And you will see Latoya Jordan Davis, stamped February 8th, 2024. Michael Elliott Johnson is the respondent. And that's the final denial order on February 8th. Let me see if I can find the petition in here. I thought I had the petition.
Was there or has there been a final adjudication on that?
Both of them, yes. And that's Exhibit 2 is the order that is the order that Mr. Johnson, Exhibit 2 is the order denying Ms. Jordan's petition. And he was granted an order on March 7th.
Did you also include a copy of that?
I do. It's right here, Your Honor. That's what I want to serve her with. That's what she's on.
Is it as an exhibit in this packet, or is
it should be exhibited in this packet, but there's a copy right there. He now has an active order against her. She's been denied an order in Kitsap County Superior Court. And while that happened, and here's what happened in the original order. When she went in on the 8th of, or what day was it? On the 9th of January and filed that, it was initially denied, but they set it for a hearing. And so when it was denied, she then turned right around and came here and filed it here. When there was a pending hearing waiting to happen in Kitsap County. And then So I think that pretty much covers it. I wanted to find the exhibit that shows that she filed it on that day.
The actual petition itself has a section to disclose other cases between the same parties.
It does, and she didn't do
Nothing
it.
in that one.
Right.
All right. Well, okay.
And so,
I understand what you're saying here.
yeah.
All right. So, Miss Jordan, I want you to respond to the legal issues that were brought up. Not the merits of any of this, just the legal issues that were brought up. And then I'm going to need to make a decision based on that. Okay. So why don't you go ahead and give me your response?
Your Honor, I believe he is talking about, I had done some rough drafts of a petition that I gave to a legal team, legal advocates team. I believe they filed some. I don't know what you mean, the legal issue.
Well, the legal issue here, not the merits of whether there should be an anti-harassment order or not, but just the legal issue as to the issue that counsel brought up, which is that there's already litigation between you and Mr. Johnson in Kitsap County Superior Court.
I don't believe that's true.
Here you go, Your Honor.
There is no, I haven't received any kind of response from them since this petition started. There's nothing in Kitsap that I'm aware of.
Your Honor, Exhibit 4.
Exhibit number 4.
Shows a filing. This is off of Odyssey.
Mm-hmm.
Shows a filing 2/12/2024. Shows completed status at this time. If you look at the docket down here, on the 12th, on page 2 of Exhibit 4, it shows that it was initially denied. And what was denied was the temporary order.
Mm-hmm.
But the court set a hearing,
Mm-hmm.
and the court has the order on the hearing.
Right.
And that's on the, I think it was February 8th. Oh, no, it's actually.
Well, I think that the preliminary issue here is actually fairly easily resolved. And this doesn't, like I said, Ms. Jordan, this doesn't have anything to do with the merits of the underlying case or the case in another county, in Kitsap County. But the statute, RCW 7.105 is clear that if another court, if a superior court is exercising jurisdiction over the parties, then the matter must be transferred to that other court.
Correct.
And it looks like, well, at least allegations are here that proceeding has produced a final judgment. In my view, if indeed that's the case, then what would happen would be that Ms. Jordan's petition might be considered by that court as a petition to modify a final judgment. I don't know, but that's going to be a decision for Kitsap County Superior Court. So, Ms. Jordan, what I'm doing here is, based on the motion that Mr. Pimentel has filed, is I'm finding, based on these pleadings, these orders and petitions out of Kitsap County Superior Court, that the Superior Court Kitsap County is exercising jurisdiction over the same two parties, and therefore I am declining to hear it in Thurston County District Court, and any hearings on the case will be heard in the Kitsap County Superior Court.
Didn't he say it was denied? I heard him say something was denied.
Well, arguments of counsel are that it was, but whatever the procedural posture of the case isn't really important. What's really important is that court is exercising jurisdiction over the parties. What the court ultimately does in terms of granting, denying, modifying orders is not really relevant.
Well, and it has been denied. You have an order showing it was denied. I'd like her to know that. And I also would like, for the record, to notice that she has, or to state that she has noticed that Mr. Johnson has an order against her, a protection order against her in Kitsap County Superior Court. Did you hear that, Ms. Jordan?
I'm sorry?
Mr. Johnson has an order against you in Kitsap County. There is a no contact order in place and you cannot make contact with him.
I learned about that Saturday.
So she does know.
Okay. So I'm just signing an order here, finding that this Kitsap County Superior Court is exercising jurisdiction over the parties and this matter will be heard there.
What is the court date for that?
Ma'am, there is no court date. Your order was denied. If you want to ask the court to reopen it or modify it, you have the right to do that. But at this point, it's been denied. And I think it was more than a month ago. So, but you need to get a lawyer to talk to a lawyer about that. But your order was denied, or your request was denied in Kitsap County.
I'm not planning on getting an attorney. I just want him to stop stalking me and harassing me. That's all. We don't have any contact. When is Mr. Johnson's next court hearing?
There are none, ma'am. It's all done. He has an order against you. Your order was denied. It's all done. But I'm not going to give you legal advice. So talk to a lawyer, show him these documents. If you can give me an address, I can send you the documents, or an email address. I can have them all sent to you.
It's on file in district court.
Okay, we'll email it to you then.
The address is on file with district court.
Okay, thank you.
Have a good day.
And that will conclude the matter for today.
Thank you, Your Honor.
All right, then the next matter that I'm going to hear is Williams versus Tron.
Yes.
And that involves Mr. Nevuli. All right, now this is Ms. Williams's petition for protection order against Ms. Tron, and it's case number 24-6. All right, then Ms. Williams, please go ahead.
Tôi xin phép trình bày vào tôi muốn chống lại bà Trân vì bà Trân đã nhắn tin riêng chửi bới, phỉ báng, sỉ nhục tôi, bản thân tôi, gia đình tôi, chồng tôi và kể cả chồng cũ và gia đình của tôi ở Việt Nam.
Yeah, what I want to do is file a petition against Miss Tran. She has texted privately to me, slandering me, defaming me, my husband and my ex, and also my family in Vietnam.
Tôi xin phép trình bày chi tiết. Vào ngày mùng 10 tháng 12 năm 2023, tôi có đăng một cái quảng cáo về sự kiện Jacquet khủng long cho một cái nhóm gọi là cộng đồng những cái người có nhóm 9 người. Và cái quảng cáo đó diễn ra vào ngày 15 đến ngày 17 tại Puyallup, Washington.
Yeah, the detail is that this happened on December 10, 2023. I did a posting of a Jurassic Park dinosaur to a group of 9 people. That the event's supposed to happen on the 15th to the 17th in Puyallup.
Sau đó thì bà Trân nói là không có phù hợp cho trẻ con của bà quá nhỏ và đứa thì đang chuẩn bị lớn. Và tôi cũng có nói về cái chuyện là tôi và chồng tôi sẽ đi và tôi nói là tôi và chồng tôi sẽ đi và chơi. Tôi không những thế và tôi cũng còn chơi cả búp bê nữa. Tôi cũng quan tâm đến sự kiện khủng long vì là tôi có quan tâm đến cái thương mại về hóa thạch. Bà Trân cười thì bà Trân nói là cái việc đi xem khủng long là dành cho trẻ con.
What happened is Miss Tran said that this event is not appropriate for kids and older kids. But I'm very concerned about this event. I'm concerned about the fossil nature of it, the fossilization impact, and also have a doll or puppet to this effect here, and I'm interested in this fossil event. After that, Miss Tran posted some pictures of her 6 to 7 month old kid, like ridiculing me, comparing to the doll that I
Lazy.
use, that I use as an image. So I don't hate this family at all. I used to give gifts to her kid, and I used to visit them. So after that, I messaged to the group that she should not be saying saying things to me and my family like that. She was saying that my husband is feeble, he's weak, he's non-American, and I keep on telling the group not for her not to say things like that. Yeah.
Then she called me crazy. She called me con hiệp bị điên. My original name in Vietnam is hiệp. Con hiệp điên, bị điên. Mày có dừng lại đi không? Tao nói bao giờ?
Then she called me crazy, or she called me crazy hip, and I wonder if she's going to ever stop calling me like that. Then I kept on telling the group not for her not to do that anymore. So what happened was she kept on slandering me and bad mouthing me. So I blocked her, and because I am the group manager, so I was able to block her and remove her as a member from this group. And as you can see on page 27, Your Honor, that she called me crazy, and she said that I am crazy. I after that I did not reply to her at all. But then at the end of the day, she gave me a long message, bad mouthing me again, slandering me again. And then I not only blocked her from Facebook, but also from this group as well. So what happened is, let me finish this part. Yeah. So what happened was on the 12th, I received a lot of messages and notifications from my groups, from my friends, different states. What happened was there was a posting again, bad mouthing me again on some social media group, not only about my body but my family, and also saying that I'm just a despicable cunt and unable to have a family, and not unable to have a family and a husband and a kid. But then I did try to tell Tran that I was separated once, but that's the extent of my family condition. And I think she does this because she's trying to make me feel bad that I'm unable to have a kid like herself. But what I know is I do not have this feeling at all whatsoever. Not unable to have a kid. That's it. Còn nói gì thêm không? Anything else?
Yes, more, thank you. Sau đó tôi có gọi điện cho cảnh sát Snohomish County.
Yeah, so what happened is I contacted several police jurisdictions, mainly Snohomish PD. They called me back and saying that I could initiate a personal protection order against Miss Tran, but I don't really want to elevate the situation to that. I just want her to stop slandering me, badmouthing me, and I don't want to elevate it any further for her to stop. And also had some help. I contacted also Stanwood and Lacey, who gave me the same advice. Yeah. Yeah. So what I'm asking Your Honor is to grant me a protection order for the 2 years of turmoil that I have suffered, as has been documented in the court paperwork. I'm personally and psychologically affected. It has impacted my work. Um, uh, and I had some consolation from my friends all over. So I want to stop Miss Tran from being my friend. I want to stop her contacting me in any manner whatsoever. That's why I'm asking, Your Honor.
All right, thank you, Ms. Williams. Ms. Williams, I was concerned about this from the beginning of this case when I read your petition and other materials. And nothing about what I've heard here today changes my concern and my views on this. But there is not a basis here to issue an anti-harassment order. And I don't even need to hear from Ms. Tran in order to know that. The reason I say this is because all of the things that you have said that Ms. Tran has done are basically issues, like you say, of bad mouthing and slandering and harming your reputation, basically saying nasty things about you. And those things are, on the one hand, not the kind of legal action that can be heard in district court, but then on the other hand, also not part of the law of harassment. So even though the police told you go to court and get an anti-harassment order, that's not something that's available to you for the kinds of things that you're saying Ms. Tran has done and said. So I don't even need to hear from Ms. Tran on this, because even if I accept everything that you have told me and what you filed as absolutely true, it still does not provide a basis to issue a no contact order. So your request for a no contact order is denied. So thank you, Ms. Williams, Ms. Tran, and Mr. Netherly, of course, as
You're
always.
welcome, Your Honor. Giờ cảm ơn hai bên nha. Cảm ơn mọi người. Và tòa đã phán quyết rồi đó, là bác đơn nha.
Thank you.
Bellew versus Taylor. This is case 24-60. Lee continued this case.
Can you hear me, sir?
That was because Mr. Taylor had needed some time to respond. And it looks like you did file some responses late last week, so I've received those and had an opportunity to review them. So, Mr. Bellew, are you ready to go ahead with your hearing?
I believe, yes.
Okay. And Mr. Taylor, are you ready too?
Yes, Your Honor.
Okay. Then before we start, can I have you both raise your right hands, please?
I do, Your Honor.
Okay. All right, then, Mr. Bellew, as the petitioner, you get to go first, so you can go ahead and present your case. And keep in mind that everything that you've previously written or filed in this case is already part of the record. Go ahead, sir.
I'm filing this because ending the friendship that was no longer conducive to both of us. I have since then been my house, my place of work has been intruded upon. And all I've asked of Mr. Taylor is to just drop everything and just to leave me and my family alone. I'm tired of my parents being stressed out by the fact that, some of the actions that has happened, presented with evidence presented of thought being followed, showed up at different places of work, school, other activities, and all I want and have asked since then is to just please just leave me alone, and is that's pretty much all I would want is just to no more contact anymore. It's been incredibly stressful for again me and my family. I am tired of wondering if they're going to be showing up at my place of work or wherever else I am. That's essentially it. I just wanted to drop it.
All right. I think I do understand the nature of your request. So if there isn't anything further you want to add, I'll hear from Mr. Taylor and make a decision. Okay.
Yeah, sure.
Okay. Mr. Taylor.
My anxiety's a little off the board today, so I'll try the best I can.
Mhm.
I was just a little confused with Mr. Blue's thoughts when he's filling out the petition with, he said, he marked the part, about the firearms and like not to take them away or prevent me from getting more. I mean, if someone was really like worried, wouldn't they like say yes on that? And another one on there. My thoughts are all over the board. I'm sorry. And clearly, he marked us as friends, and clearly it was more than friends. He does a lot of put something in front of you and pull it away. Put something in front of you and pull it away. For instance, 4 to 6 weeks before he decided it was over, he gives me this long speech when we're driving around in his mom's truck about how if something ever happened, he had never walked completely out of my life. He'd always be some sort of a friend of some sort. It's like he was setting everything up for this day or something. I also noticed on his petition, he says that he had to seek counseling for the mental anguish and whatnot. And his counseling was started before that, and I submitted a text where we were talking about it to prove that it was before that. So it's not because of the day we broke up, it's because he has a lot of his own stuff going on. We both have a lot of our own stuff going on, and we kind of understood each other's stuff going on. And then like he's learned it all to use it against me. He has multiple profiles online. He says I'm the one with multiple profiles and harassing him. He has 8 that I know of that are his, and I'm sure there's a couple more. And that's just in one platform website. He wants his privacy and to be left alone. We're using a platform website that's map-based. It shows your picture and icon on a literal map of where you are, and it shows everybody where you are. So I don't understand how I'm seeking him out and stalking him when we're both doing the same thing. We're on the site to find somebody, and our icons are shown where we are on a map. Like, I don't understand. You can't go on the site to try and find somebody and not see each other. This gay community is very small. In Olympia, it's not real big. We wind up with the same people in and out and back and forth. His ex's roommate picked me up downtown and took me back to his apartment, not knowing that he was at his ex's house that night. And then, like we run into each other. Like it's gonna happen. It's inevitable. And I'm willing to be civil and a girl and like, hey, on our merry way. But anytime and every time I have wound up somewhere where Mr. Blue is, he goes ballistic and screams and yells at me. But I'm the one that's being crazy, according to Mr. Blue. Friends have said I should file on him, including Pac-Man. It's like, I'm trying to not ruin things. He knows with this on my record, I'll lose my career. He has threatened me multiple times during our relationship, friend or not, whatever he wants to call it. If I didn't do something or if I did something a certain way, he'd either file APS on me or he would call the police on me. And like the night at the ex's house, and he ripped my keys out of my hand, pried my door open to my car. He has a set of my house keys. I had to get a locksmith out so I could get in my house. He's like, I didn't pay for any of that. He the one started it, but okay. Everything he's accused me of, he's doing to me. Apparently I care more than him, and I want him to be happy. I want him to have a good life. I want him to go on, but we are going to cross paths. We are going to, eventually, it's going to happen again. And if he gets his order, how, I could turn around and get one too, and then we both can't go anywhere. We can't do anything. Like, can't maybe adults get along and just like, I have a whole bunch of stuff written here. I could read it all. It just seems silly and ridiculous to me, Hunter.
Well, obviously, this is a little bit of a difficult and fraught situation for both of you. It's obviously, as far as I can see here, causing both of you a pretty good deal of stress. But the way I need to look at this is whether or not Mr. Blue is the petitioner. So I need to look at whether or not he has established that he's entitled to an order for any of the various bases that there are to get one, including stalking, which I think is the one that he had identified that he was after. And So I have to look at the facts as alleged by both of you, make credibility determination, and consider whether or not what Mr. Blue is alleging has occurred here would constitute stalking. And Mr. Taylor, you point out, and I think reasonably, that it's a small community here in Olympia. People are going to run into each other. That's not anything that only happens if somebody's being stalked. That's just the kind of thing that happens by chance. And when you consider your social groups and your interests and your what restaurants you go to, things like that, then those chances increase, because you're talking about a smaller and smaller group each time you consider those things. So yeah, you're right. I mean, people are going to run into each other in a town this size, and that's not any kind of, in and of itself, that's not any kind of a violation. That's not even a violation of the protection order. But what I'm looking at is not coincidental things like that. I'm looking at intentional things. So in other words, is the conduct that's alleged here the kind of thing that displays an intent to stalk another person? And by that I mean getting in contact with them, showing up where they are, letting them basically know that they're being tracked or watched. And is that sort of conduct or activity, would that cause a reasonable person to be in fear for their safety? And I think that's what Mr. Blue is saying, is that's what he thinks is going on. And that's the evidence that he's submitted to support that. So in any situation, any person, whether or not there's any, criminal conduct going on or anything like that, they've got the right to not be contacted by another person if it's harmful to them. Anyone can do that. Just tell a person, don't call me, don't come by, none of that. And if somebody honors that request, then fine, there's not a problem. But it's the contact that occurs despite that making plain that they don't want it. So, my concern here is that, Mr. Taylor, my concern is that what's happened here is that after the end of the relationship, as Mr. Blue characterizes it, that there was a continuing effort to remain in contact and to display to Mr. Blue that despite whatever he may want, that there would still be contact initiated by you. That's what I'm looking at. I'm not looking at whether you're going to show up together in the same places or that the same people and that sort of thing. So did you have something you needed to say?
The evidence I submitted, it shows, like on the 12th, I wrote him a I'm done goodbye letter. And then on the 24th, he reaches out to me and he starts it again. He reaches out to me. He's contacting me. Like
I saw that.
He's done that multiple times through the relationship before the breakup. He's said, no, don't talk to me, don't, and then he reaches out to me again. I think there was another one, December 31st to January 3rd, where he reached out to me and was like, hey, and I was like, why are you reaching out to me? Like, I was done. Like, why did you say hey last night?
That was before any of this happened.
So
it was very common throughout our friendship to hear those things. It's not like, it was never said and then it said once, and it was said common. It was very common.
All right. And I get that, Mr. Taylor, and it's not altogether uncommon to hear those things in a situation where somebody is being stalked. If they are, then to point to a response to a text or a response to a contact and say, well, that's evidence that they don't really want me not to contact them because they're reaching back out. That may or may not be true. It depends on the context. So I've got to decide this based on the strength of the evidence. In other words, Mr. Blue's got to show by a preponderance of the evidence, the greater weight of the evidence, that he's entitled to this order. And this is a close one, because Mr. Taylor, you're offering up explanations for, the course of conduct that's happened after the end of the relationship that, that are reasonable explanations, that are non-threatening, that are just normal things that happen, as you said. And Mr. Blue is saying, no, they're not just coincidences. They're designed to, basically intimidate me. That's his position. And like I said, this is a close call, and I'm mindful that if an order is to be issued, that imposes significant restrictions on another person, potentially subjecting them to, criminal consequences. So that's why the law requires that the person who's asking for an order has to show by a preponderance of the evidence that they're entitled to one. And Mr. Taylor, a lot of what you say is reasonable and makes sense to me. So you've also said that you aren't interested in having any further contact with Mr. Blue. So what I'm going to do is, on the balance here, find that Mr. Blue has not carried the burden of showing by preponderance of the evidence that stalking has occurred. And I will decline to issue an order. So the temporary order will end today. But I will say this: if there's any further unwanted contact, if a pattern continues or develops that shows that Mr. Blue is continuing to receive unwanted contact or unwanted surveillance, that would show perhaps that there is such stalking going on.
The evidence that has already been submitted has shown multiple instances of vague threats, multiple changing of phone numbers, and showing up non-coincidentally at the places that I have been to. And I understand the whole small community part, but I don't intentionally. I haven't gone anywhere near them in this entire time, and yet I had multiple instances of him showing up at specific times at specific places where I am, and I've asked him to please just leave me alone. I don't want, I'm not trying to ruin his career, but I have asked him multiple times, and my parents' health is being affected by this Malay thing because they're afraid of what is, him sending pictures of my house at whatever time when he's not supposed to be there.
I've heard from both of you. I've read all of the substantial information that's been filed by both of you in support and against the issuance of this stalking order, and I made the ruling that I have. It's like I said, it's a close case. It's kind of you both seem equally credible to me. You both seem equally concerned about the situation, and I also think, from what I've heard, that neither one of you wants any further contact, except, as you said, it could coincidentally. So on that basis, based on that evidentiary standard, that's my ruling for today. Casio versus Kathleen Coleman.
Good morning, Your Honor.
This will be case number 24-7. All right. And Ms. Casio, are you ready to go today?
Yes, I am, Your Honor.
Okay. Ms. Coleman, are you ready to go?
Yeah,
All right. Can I have you both raise your right hands, please?
I did.
Yes, we do.
Okay. All right. Ms. Casio, you're the petitioner here, so you get to present your case first. And keep in mind that everything that has been filed in this case as part of your petition is already part of the record in the case. So go ahead, Ms. Casio.
All right. Your Honor, I just request a civil protection order be granted for me in my personal workplace on my behalf because this former patient, Kathleen Julie and her others, Coleman, threatened me and to say, I'm going to punch you during a visit for massage therapy and Ayurvedic care, right? And she is under taking antidepressants. And let's see, it's a little unruly to find that out. And then on the day that's filed that, that I took care of her, it really scared the ever living God out of me. Like, I took care of her for a while, and then I saw other sides of her that weren't exactly, that I wasn't sure how to manage. In the court paperwork that I did file, I said, I actually called Western State to find out how do I take better care of her. I even asked her niece, hey, what happens when this happens? And she said she runs and she leaves, right? And I'm really more than concerned about the fact that I can't provide for her. I don't have the means to do so. I don't wish to be a part of her care plan anymore. And I don't want my places of residence have to worry about her either, as far as the fact that when she goes to like the Oli Float, or she comes to see me at my other business for, and what version am I going to get of her? On certain occasions, she's been okay. And then other days, I'm like, I don't know that she's there per se. She has had, she entered in a relationship with me where she wanted me to care for her because she had, a motorcycle accident. All right. And then she said that she is, needing assistance and help, in which case I did work on her quite a bit. And then, with the body work that I actually do, it can go ahead and bring about certain kinds of emotions. However, most of the time we were fine up until I saw that this incident really made me reconsider the relationship that I have with her, saying that she is going to punch me. I don't know if she's going to show up at a place of work or with my other colleagues that she asked for their help of what she's going to do to them. And it basically made me really unnerved as to what to do and how to be there and how to handle the situation. It's very unusual for me, actually. All right. And I just asked for that she can receive medical care that she needs, that she leaves me alone in my place of work. All right. And places of work were my own business and over at Oli Float.
All right. Is there anything else?
No, Your Honor.
All right. Then, Ms. Coleman?
Hi,
Your
Your
turn.
Honor. Okay, so first thing I want to declare is that I never threatened to physically harm Miss Casio. It never happened. She did come up to my house. You sound like you pay very close attention to documents, which I'm very happy to hear. So I would assume that you've reviewed that. I have a text message in there saying, if things are going to hurt, I can't do it. I might have to cancel. And then I included a text message in there about, could I come pick up some herbs and salves from you? And then there's a print screen on the bottom of it of her phone call to me right after that. Jessica had a habit of that where I would text her with an issue, or I couldn't make an appointment, or asking another question. And instead of ever putting anything in writing, she would call. So that was one of her claims in her petition, was that I had called her on her phone. You'll also see a text message in there of her asking me to call her. So that was a normal method of communication. She's absolutely right. I did contact one of the co-owners of Oli Float. His name is Dan. I explained to him, which honestly, when I was reading through the wax, it was actually my responsibility to let him know that he had a person in his part-time employment who they were promoting on their webpage with a direct link to a business that she's operating fraudulently. That is the only reason that I contacted him, because if they are promoting somebody that's operating a business fraudulently and they don't know about it, they're still liable. But if they do know about it, they're culpable. So I let him know. It took me a couple of phone calls to the front desk to get the front desk people to let him know that I was trying to contact him. You can see by the little refund check that he gave me with the nice little note that our conversation, although very sad, he felt really bad that I got high pressure sailed into buying those floats. So he refunded me for the floats. But he would not take responsibility for anything Jessa did as far as her massage therapy license. So, and including outside of his business, and she just stated to you, my business. She, unless she's gone in the last couple of weeks and gotten an active business license, she had no business license. So she was misrepresenting that. So long story short, I sent her an email on the 21st explaining all of this. We need to sever our relationship. This is the money I feel I'm owed back. This is why. Print screens of her business being registered as closed with the Department of Revenue. Print screens that her massage therapy license is in fact active. But what that actually does is say that she needs to operate under a certain set of WACs and RCWs as far as providing documentation, treatment notes, keeping records. And on top of the fact that she's submitted these things, and I also have the RCW here covering discovery quests and compulsory orders. She has taken a document from OliFloat, which is not where I was doing business with her. It's where I initially did business with her and how I met her. But I was doing business with her at her business, which was being misrepresented as an active business without a business license. And I provided you with those two separate financial transactions. So she's actually taken a HIPAA protected document, which is my new client entrance form, from OliFloat, which has absolutely nothing to do with this. I've already talked to the owner. I never had to call back. He was extremely gracious. And she's misrepresenting it as her new client intake form. That form does not belong to her. It never should have left OliFloat's HIPAA protective storage, however that may have been, whether it was in hard copy or digital. She had no right to take that and make it part of any public record. Whatever her false accusations are about my multiple personality disorder, it's all just a slanderous and retaliatory attempt to get me not to take her to small claims court, to get me not to report her to the Department of Revenue, and to make it so that she can have some kind of court order that I cannot turn her into the Department of Health. And one of the main pieces of evidence there is that she backdated a fictitious letter to a doctor who, that's not even my doctor's name. In her heading, she puts her place of business, Roadmap Therapeutics, and OliFloat's contact information in her header, writes a letter to a doctor that doesn't even exist. I mean, at least not in my world, and dates it on the 19th. And I have proof in there that she texted me on the 22nd asking me did I want to meet her in the pool, or did I want to meet her down at her office? Now, does that sound like somebody who's afraid I'm going to hit them? This is all just retaliation. That's all.
All right. Anything
Sorry.
else?
No, that's it.
Okay. No, I know Ms. Coleman, I know you've submitted quite a lot of information here about issues like licensing and whether, you may have a claim for damages against Ms. Casio. I get that you're telling me that. I'm just making it clear that at this point in the context of this hearing, this court's not going to decide the merits of any of those issues.
Absolutely.
But I understand that you're telling me those things in order to demonstrate that you believe that these are the things that are motivating Ms. Casio to file this action against you, and that in reality, you haven't made any threats to her or given her any cause to be afraid of you other than these legal issues that you are advancing as other potential causes of action. I understand that claim. So, and once again, you've heard me say this before earlier this morning that, in order to prevail on a anti-harassment claim and get an order granted, a person who petitions for an order has to be able to show by a preponderance of the evidence that they're entitled to one. In this case, the order that that Ms. Casio has requested is an anti-harassment order, and those are based on and in order to get one, a person has to show that there's been a course of conduct directed against them that's detrimental to their physical or mental well-being, and that conduct serves no lawful purpose and is being done, is having the effect on their mental or physical well-being that a reasonable person would suffer. And looking at this case when the petition came in, it's understandable to me why the court would grant a temporary order based on the allegations, but like everything else, there's at least two sides to every story, which is why we have hearings like this, so that we hear everybody's side of the story in order to make a decision. And here today, now we've also heard from Ms. Coleman, and I am satisfied with the explanations that Ms. Coleman has given, that her actions in regard to Ms. Casio are not harassment, and that whether or not there's any merit to any of these claims that there are potential actions for damages, or that Ms. Casio is operating outside of the law in terms of business licensing or medical records privacy, no ruling on that issue. However, it certainly explains Ms. Coleman's actions, and so I'm going to find that there has been no harassment here and deny the petition for an anti-harassment order.
All right. Your Honor, may I ask you a question? And you may not be able to answer it.
It's possible. You can always ask, but I will do my best.
Okay. So I did not file a anti-harassment petition in return and stuff. I just figured that would all look like retaliation on my part. But I also hadn't seen all these documents with my personal medical information, or the fact that she would actually write a fictitious letter to somebody who doesn't even exist and include it in part of the court record just to backdate something. Now I am a little bit concerned that she may continue to try and do things like that. Can you just tell her, knock it off, and then we can be done with this and I can go ahead with small claims court? Or I don't know.
You were right the first time. I can't give you any advice.
Okay. Sorry. All right. Got it.
You're kidding me.
Oh my God.
You have got to be kidding me. What is going on today? This is a joke. This is a joke. Today is an absolute joke. We need an interpreter.
I need an interpreter when I cannot express myself sometimes.
Oh my God, sir, put that cigarette out. I don't give a crap that you are outside of this. What is wrong with everybody today? You know what, Miss Reed, we're going to start bringing people in person. He's going to learn how to act in a courtroom.
Can you hear it? Can you hear it? Ma'am? Ma'am? Can you hear it?
No.
Okay.
I have no patience for that. And trust me, out of the day, I'm sitting up here,